All right, we are live now. So Belief, over to you.
Good afternoon. My name is Myrangan and I'll be the bailiff for this session. With me today are Ria Gretel as the assistant bailiff and Adriana Lee as the timekeeper. Judges, we will begin a round whenever you are ready.
Ariff, are you ready? Lavinia?
Yeah, I'm ready.
Okay.
Yes.
This honorable court is now in session. The judges for the session are Young Ariff, Lavinia Kumarendran, Young Ariff, Ariff Rozhan, and Young Ariff, Christopher Leong. The presiding judge for this session is Young Ariff, Christopher Leong. The appellant is represented by Jonathan Lim and Siti Nazatu Nadia. The respondent is represented by Chua Kai Sheng and Chen Wei Lin. Counsels for the appellant and the respondent are each allocated 45 minutes to present their respective cases, which is inclusive of a maximum of 5 minutes each for their rebuttals and surrebuttals, respectively. We will now invite the lead counsel for the appellant to begin their submissions.
Before I begin my submission, may I check with your lordships and your ladyship if the audio is clear and I'm visible?
Yes.
Yes, for me as well.
Much obliged. May it please this honorable court, my name is Jonathan Lim, lead counsel for the appellants. I appear before this honorable court with my learned friend and co-counsel, Ms. Siti Nazatu Nadia. Appearing for the respondents are my learned friends, Mr. Chua Kai Sheng and Ms. Chen Wei Lin. I'll be addressing the court pertaining to the first two issues in today's proceeding with regard to the admissibility of the additional evidence in question. My learned co-counsel will be addressing the issues pertaining to intra-corporate conspiracy and the issues of exemplary damages. I will be using 25 minutes of this honorable court's 20 minutes of this honorable court's time to address my submission. My lords, my lady, the admission of additional evidence at an appellate stage is a discretion awarded to appellate courts and ought to be used in extremely sparingly circumstances. Even when there are serious miscarriages of justice, this discretion is often not exercised by appellate courts, and it is our submission today that the appellant stands firm that today should not be such an exception. Several facts are in support of us today. We say that the source of the document is of an unknown nature, together with the fact there is a lack of verification, together with the fact that the alleged whistleblower in question has not been verified. In support of this proposition, my lords, my lady, the appellant forwards three arguments in order to substantiate our proposition. The first argument being that it does not fulfill the statutory requirements under Section 69(3) of the Courts of Judicature Act and the Rules of Court of Appeal. This is followed by our second argument, which is my second argument, which says that the evidence in question is inadmissible under Section 73A of the Evidence Act. And lastly, we will forward a proposition regarding public policy and how finality in litigation ought to be maintained. On the first submission, my lords, my lady, the appellant submits that the statutory requirements are indeed not fulfilled by the respondents. In support, the reference is made to the Section 69(3) of the Courts of Judicature Act and Rule 7, Sub-Rule 3A of the Rules of Court of Appeal. Both provisions contain, essentially allow for evidence to be admitted in only special circumstances. Special circumstances is defined as in accordance to the landmark English Court of Appeal case of Ladd against Marshall. In this particular case, His Lordship, Lord Denning, enunciated three principles in order to determine the admissibility of evidence. The three principles are as follows. First, the letter in question had not to be obtained with reasonable diligence during the course of the trial. Secondly, the evidence in question needs to have a certain level of influence, although it need not be decisive. And last but not least, the evidence in question has to be credible in nature. This is to say, either the source or any relevant facts to the evidence has to be credible, and the credibility ought not to be challenged. It is at this juncture, my lords, my lady, It is also pertinent to note that in accordance with the case of Maxi Saga Sendian Berhad against Silver Concept Sendian Berhad, that that stands for the proposition that all three elements ought to be satisfied. Insofar as the appellant is able to prove to this honorable court that one element is not satisfied, the respondent is not able to admit said evidence.
Sorry, counsel, what case did you just cite?
Apologies, my lord. The case of Maxi Saga Sendian Berhad against Silver Concept Sendian Berhad.
Okay.
Much obliged, my lord. On to the first element.
This is at which level of the courts?
It's a Court of Appeal case.
Thank you.
Much obliged. On the first element, we say that reasonable diligence was indeed not exercised by the respondents. The substantive facts to prove this is that the letter in question was indeed dated on the 1st of June 2020. If I may refer this honorable bench to the moot problem, the clarifications and corrections document, in particular page 3, paragraph 4. Are your lordships and ladyship with me? Much obliged. As you can see, as evident from here, the letter in fact was dated the 1st of June 2020. Prior to any civil proceedings and prior to any incorporations of any companies. The very fact that civil proceedings were only commenced the year after that means that there was no reasonable diligence exercised on their part. Furthermore, we are of the proposition that given that there is no definitive time of the discovery of said letter by the whistleblower, we urge this honorable court to accept the proposition that the date of the letter is to be regarded as the time in which the respondents ought to have discovered said letter. On the second issue, my lords and my lady.
Sorry, counsel, who is seeking to adduce this? The appellants, right?
No, my lord. No, my lord. It is the respondents who seek to adduce the letter. Much obliged. On the second element, my lords, my lady, the appellant humbly submits that the letter in question is indeed not of important influence due to the very fact that the High Court judge at trial had already ruled in favor of the respondents pertaining to the issues of conspiracy. We say that in this particular element, the important influence test enunciated by Lord Denning is not achieved, given that the case at hand has already been decided in favor of the respondents. What the respondents are seeking to do at this particular juncture is to further strengthen their case, and this ought not to be permitted, and it is not of significant influence pertaining to the material facts of today's case.
But Mr. Lim, sorry, Lavinia, you wanted to say something?
Go ahead.
Sorry, Mr. Lim. This document that is sought to be adduced is said to be a letter issued by the appellant.
Yes, my lord. That is the case.
Well, it's issued by one of the appellants, Grey Eye to Grey Matter.
Yes, my lord. My client is Grey Eye, and it is issued to our subsidiary, who is not a party to the proceedings.
Yep. So why would you say that the respondent should have and could have discovered this letter with due diligence as of the date of the letter?
This is due to the mere fact, my lord, that the letter in question was indeed dated the 1st of June, and there existed other avenues for the respondent to seek in order to discover said document. They could have subpoenaed the document, my lord, or at trial there may have been a discovery, all of which the respondents had failed to adduce that document at that particular juncture.
I think the allegation here is that this letter was suppressed. That this letter is an internal letter, and that it was incumbent on the appellants themselves to have voluntarily disclosed a material and relevant letter. What would you say to that?
Yes, my lord, I understand the proposition that you're forwarding. However, it is the appellant's stance that the particular letter at that juncture was indeed not suppressed, given that the letter in question was exposed by said whistleblower at that particular time. We say that the letter could not have been traced by the company given the vast amounts of documents in my client's company.
Okay, carry on.
Much obliged. On the third element, my lords and my lady, this is where we challenge the credibility of the evidence and the source of the evidence coming from the respondents. Here, it is our
Counsel,
Yes,
can I just ask, you do accept that the letter is relevant though, don't you? In this case.
No, no, my lord. We are not of that proposition. We say, as enunciated just only, the letter is of little significance to the proceedings today.
Okay, all right.
Much obliged, my lord. This is where we come to the credibility element of the three-part test in light and martial, my lords and my lady. Here, we say that the letter in question was indeed a forgery by an ex-CEO of my client's company. In support of this fact, may I refer this honorable court once again to the corrections and clarifications?
No, I think we've read that. It is allegedly signed by Marcel, a former CEO who resigned in January of 2019, some 1.5 years after the date of the letter, 6 months before the contract.
Yes, that's right.
I think we are aware of that allegation, but don't you think, counsel, that that is a matter of weight?
Apologies, my lord.
That's a matter of weight. That is, the respondents say that this is a letter that is an internal letter. It is relevant and material because it bears out part of its allegations. The appellant's response is that, oh no, this letter is a forgery. Doesn't that go to the veracity of the evidence? That means the weight of the evidence rather than an admissibility point?
No, my lord. We are not of that position. We would humbly urge this court to be of the proposition that the letter in question ought to be inadmissible as a whole, given the forgery of the particular evidence. And if I may support this proposition, it say that it is significantly easier for said letter to be forged, given that the letterhead, the stamp, and all of things that are accessible in said company could be done by any particular individual except the CEO in question.
So counsel, what is, without going into the trial of this allegation of forgery, what is it that the appellant rely on the face of it to show that this is a forgery? You are saying that it is not a matter of weight, for the parties to argue after it's admitted. You say it is right from the beginning, ab initio, it is clearly a forgery and therefore it is an admissibility point. Do I get you there?
Yes, my lord.
So why do you say that? What is it that is so apparent that will ground what you just said?
The fact that supports this proposition, my lord, would be the very fact that the said employee was terminated 1.5 years prior to the letter.
I see. Okay. Okay, please carry on.
If I may, my lord, in support to this proposition, say that this is assuming the letter is a forgery. In the event this honorable court does not buy the proposition that the letter is of a forgery or fraud, and this is where we put a large caveat on this argument, we say that the contents of said letter are still inadmissible via the other rules that we prove in the case of under the exceptions of under the criteria of law against Marshall.
Namely,
the elements of reasonable diligence and the important influence. So, assuming this court says that assuming this court is of the view that the letter is not a forgery, we say that the other two elements have been satisfied.
Counsel, do you accept that ultimately it is still wholly within our discretion, my learned brother and sister's discretion, as to whether we would admit this evidence?
Yes, my lord. It is entirely up to the court's discretion to admit.
Would you have an authority for that? Because you referred me to Maxi Sega, which says Court of Appeal decision, which says that the three elements in Ladd and Marshall are cumulative, and therefore all of them must be satisfied, right?
Yes, ma'am.
So my question to you is, assuming that not all of the three ingredients are satisfied, let's say we are with you on one of your arguments as to, for example, authenticity. And nevertheless, you say we have a discretion. Is that correct? Or are you saying that we do not have a discretion?
Apologies, my lord, I may have misinterpreted the question from your lordship. The discretion is as to determine whether the evidence ought to be admissible with regard to the rules in Ladd against Marshall.
Okay. Okay.
Counsel, if I may, on the second consideration that you mentioned earlier, on the issue of whether it has a determining influence, would you agree that the whole issue here is whether or not the directors of the company were siphoning out money from Grey Eye to its group of companies?
Yes, my lady, that is the issue.
And having that letter and its contents that we know of here, would you not say that that would have an important influence on the result and outcome of the case? Because this is an issue in dispute here.
My lady, in addressing that, we say that it is of relevance. However, it is not of important relevance given the fact-finding exercises that have occurred at the trial court. Namely to say that there have been other pieces of evidence examined in order to prove this particular point, the alleged point against my client. However, due to it being of a lack of severe influence, meaning to say not raising an entirely new issue as a whole, we have the proposition that it's not of any important influence.
But you will concede that it is an issue in dispute here. The very nature of the allegation that there were money siphoned out from Grey Eye to the group of companies. That is an issue in dispute. Right?
Yes, my lady, that is. We are willing to consider. And my learned co-counsel will be expanding further on the issues at a subsequent, during her submission. Much obliged. Much obliged. On the second issue, my lady and my lords and my lady, we say that the evidence in question is inadmissible under Section 73A of the Evidence Act. My lords, my lady, the general rule pertaining to evidence is that an evidence has to be called by the maker of said evidence in order to be verified. Meaning to say, the producer of said evidence has to be called as a witness in order to verify said document. This is the general rule. However, exceptions to that do exist, and it is Section 73A(1) and subsection 1 and subsection 2 of which we urge this honorable court to view. The proposition for this, meaning to say that the first element is the element of knowledge, meaning to say and this is in reference to subsection 1. The maker of said statement has to have personal knowledge of the particular fact in the evidence, meaning to say in this case the letter. What I'm trying to forward here, my lords and my lady, is that Mr. Marcel, the CEO, had to have knowledge of the particular events that happened in the letter, meaning to say the siphoning of monies. However, it is our position, and as can be seen in clarification number 4, Mr. Marcel has been terminated long before any contract had came into nature with my client and the respondent. Therefore, it is our position that our clients, the appellants, had no knowledge whatsoever. And Mr. Marcel had no knowledge whatsoever of said evidence. Continuing this and extrapolating from this, my lords and my lady, we propose to this, we submit to this honorable court that subsection 2 of 73A, 73 capital A ought not to be recognized, as the respondents had not taken reasonable efforts in order to secure the attendance of a witness, meaning to say either the whistleblower or Mr. Marcel. My lords, my lady, it is the onus of the respondent to verify their claim, meaning to say that they are under the obligation to prove said claim. Section 73A, subsection 2 is...
Mr. Lim, can I just pause there? we are no longer at trial here. We're at the appellate stage. So there really isn't any, what do you call, viva voce evidence, no witness evidence taken at this stage. So, but I gather that your submissions thus far has been on the basis that the maker has to be called and so forth. That will be at trial stage.
Yes, my lord. I understand your proposition. However, the view of my clients here today is that at the appellate stage, in order for evidence to not fall under the calling of a witness, the court has to be satisfied that undue delay or undue expenditure would occur onto any party in the proceedings. In particular, subsection 2. This is the discretion afforded to the courts. And it is our submission today that there is no undue delay or any undue cost caused onto the respondents in order to adduce said maker of statement to produce testimony, or even in forms of affidavit. Does your lordships and ladyship require any clarification?
What are you trying to say, that their failure to call a witness means that? What's the effect of that?
Apologies, my lord. Before I answer the question, could I get some extra time to address your lordship's question?
Yes, please carry on.
Much obliged. Yet, in answering your lordship's question, yes, their failure to substantiate their said evidence is what is not allowed. That's why the evidence should be inadmissible.
That's why the evidence should be. So you're saying that because they failed to call the witness, then that is the reason why the evidence should not be allowed in. They should have called in the witness. Is that what you're saying?
Yes, my lord.
At trial.
Be it at testimony or even at this stage, either through affidavit. The facts are silent on this, but yes.
Yeah. So they didn't call the witness at trial, therefore it should not be allowed in now. Is that your point, right?
Yes, my lord. And they have also
thank
not
you.
got much obliged. Lastly, if I may run this honorable court through my last submission pertaining to the public policy and how finality in litigation ought to be ensured. In support of this proposition, if I may refer this honorable court to the House of Lords case of Mullahan against Mitchell, apologies, wherein Lord Pearson emphasized the importance of finality in litigation occurring. This proposition, my lords, my lady, was further accepted by the Malaysian Federal Court in the case of Wofat Jan against public prosecutor. Based on the plethora of case law that we have submitted pertaining to this submission, we say that we are of the view that what the respondents are trying to adduce at this particular juncture, as said earlier in said submission, is merely to strengthen their case. It is wasting the resources of this honorable court to consider evidence at this stage upon conclusion of a trial. The fact-finding exercise is a duty for the trial court, and the discretion ought not to be exercised by this honorable court in order to ensure that litigation is not unnecessarily prolonged or the costs are not unnecessarily increased. Therefore, on the facts, we are able to say that what the respondents have suggested to us today, what the respondent is submitting to this court today, shall not be able to stand insofar as one of the elements is able to be proven, together with the discretion of this court not to admit said evidence. Does my lordship and ladyship require any clarifications pertaining to the submissions?
No, nothing from me. Ariff?
Yeah, nothing from me. Nothing.
Yeah, nothing.
Nothing.
Much obliged.
Mr. Lim, thank you.
Much obliged. If I may not be of any assistance to this court anymore, I humbly end my submission here. Much obliged. May it please the court.
Thank you. Yes, can we hear from Miss Siti Nazatul Nadia? Are you ready to address us?
Yes, my lords and my lady.
Yes.
Can I know if I am both audible and visible to all of you?
Yes.
All right, thank you. Why is it so unlawful about creating subsidiary company when it is the nature of the business itself to be allowed to do so based on the Companies Act 2016? Just because the incorporation took place, it does not fulfill that our client, the appellant, caused any fraudulent activity that the respondent might claim. And with that, may it please the court, my name is Siti Nazatul Nadia, the junior counsel representing the appellant, Grey Eye, and its directors. I will be addressing two main issues in my submission, mainly the third issue, which is in regard to the applicability of the intra-corporate conspiracy doctrine, and fourth issue being that which is regard to whether the amount of exemplary damages provided by the High Court is appropriate in our current case. My lords and my lady, in the present case, the respondent's contractual obligation can be found when they made an offer to Grey Eye revolving a credit facility of $100 million in exchange of 2% of Grey Eye's profit at the end of each financial year. This offer was accepted and then formed a contract between the respondent and Grey Eye. My lords and my lady, it is worth noting that the agreement formed between the parties in this case were just Grey Eye and the respondent, not Grey Eye, which are inclusive of its three other directors because they are simply functioning under separate legal entity, which I will further elaborate in my submission later. My lords and my lady, to address the first issue, whether Grey Eye and its directors, Elon, Tony, and Mark, ought to be collectively held liable for conspiracy, the counsel for the appellant stands firm that they are not ought to be collectively held liable for conspiracy because of these two main reasons, being that first, there is no cause of action in the thought of conspiracy. Second, even if the element of conspiracy is evident in our current case, there is no intra-corporate in nature in our current dispute because the appellant is a separate legal entity from its other three directors. My lords and my lady, it is established in the case of Yap JH against Tan Sri Loh Boon Siao and others in 1991, which is a court of appeal judgment. With regard to the thought of conspiracy, the following elements need to be satisfied at this very interlocutory stage itself. There are four elements, my lords and my lady, being that first, an agreement between two or more persons is evident. Second, an agreement for the purpose of injuring Oracle Bank. Third, that acts done in execution of that agreement resulted in damage to Oracle Bank. And fourth, being that damage is an essential element, and where damage is not pleaded, the statement of claim may be struck out. My lords and my lady, it is clear that the very first element to be shown must be an agreement between two or more persons for the purpose of injuring Oracle is not foreseen in the current case. Grey Eye being the only entity involved during the agreement and even when the contract was executed will not amount to the other directors to be liable. My lords and my lady, if I may...
Counsel.
Yes, my lord.
Point of clarification. The defendants who are now the appellants, it's just not Grey Eye, right? It's also the directors.
Yes, my lord.
Yeah, okay.
So for the appellant, it will be Grey Eye and its three other directors, my lord, which is the directors of the subsidiary company.
Sorry?
Which is the directors of the Grey Matter and Grey Core in this current case.
The directors are directors of which entity?
The parent being that in the same Grey Eye group of companies itself, my lord.
Sorry, my question is, the directors are Tony, Mark,
and Elon.
And Elon.
Yes, my lord.
They are directors of which company?
They are directors of a Grey Matter, Grey Core, and also Grey Eye in the current proceeding, my lord.
Oh, is that correct?
Yes, my lord.
I think the facts show that Elon, Tony, and Mark are the founding shareholders of Grey Eye and are the directors of Grey Eye. But the board of directors of Grey Core and Grey Matter are different people. Is that correct?
Yes, my lord. I might have misinterpreted your question just now. Yes, my lord. I'm so sorry. Moving on to my argument, my lord, as can be seen in the case of V. Wen Kwai against Yam Kong Seng and others, Zainun Ali, the former Chief Justice of Malaysia, said in a judgment at paragraph 25, clearly stated that a director or an authorized officer of a company who executes an agreement or enters into contract on the company's behalf is merely acting as an agent of the company and is thereby not personally liable for breaches or acts done by the company, unless there are express provisions in the agreement or the contract itself or other documents such as personal guarantee or letter of indemnity or undertaking. From the paragraph, my lords and my lady, it can be deduced that the general rule of law is that an authorized officer of the company who executes an agreement on the company's behalf shall not be personally liable for any actions of the company. On the other hand, if the directors or shareholders has entered into an agreement or contract such as a personal guarantee, then they shall be liable as the guarantor. My lords and my lady, however, in the current case, my client, the appellant, did not have any agreement or contract with the respondent that states my directors will be the guarantor in our current proceeding.
Counsel, I think there's no question in this case or issue in this case about privity of contract. I think the allegation or the cause of action here is for intra-corporate conspiracy.
Yes, my lord. I will be addressing it now in my submission, if I may, my lord. All right. Intra-corporate liability essentially abolishes the notion of separate persons in company law, which generally would set off a bad precedent in our current court. There is already an established thought of conspiracy to deal with these situations, which is why the Counsel for the Appellant stands firm that the principle of intra-corporate conspiracy doctrine shall not and will not be applicable in this current case. As the principle of intra-corporate conspiracy doctrine is derived from the US case, my lords and my lady, we are clearly stating that this is not aligned with our current proceedings for today, and the Counsel for the Appellant would strongly affirm that these principle and doctrine should not be applied in the current proceeding, and that we should refer to the Malaysian law, which clearly satisfies this element under the Companies Act of 2016. And if I may, my lords and my lady, if you refer to section 20 subsection 1 of the Companies Act, in summary, it is stated that it is established a company has a separate legal personality from its members and will continue its existence until it is removed from the registrar, my lord and my lady. Furthermore, this section is to be read together with section 21 of the Companies Act, because today they are saying that transaction is not foreseen and available in the current circumstances. My lords and my lady, it is clearly stated in section 21 of the Company Act that a company can be sued, can acquire, own, develop, or dispose of any property, or if I may emphasize, my lords and my lady, it is clearly stated is able to do any act which it may do to enter into transactions. And these can be seen in our current case, where transactions of money being made from the parent company, which is the holding company, to its subsidiaries, my lords and my lady. Moving on, my lords and my, yes, my lord.
No, I was just whether or not you could address us directly now on the question of the allegation of intra-corporate conspiracy. So
Yes,
I understand your submissions that we ought not to follow foreign jurisprudence on this point. Could you address us as to whether or not that this principle of intra-corporate conspiracy is present in Malaysian law, or whether or not it has an equivalent in Malaysian law?
Yes, my lord. I will now continue in my submission, if I may. So in the current case, it is not even present in our current proceeding and not even present for the usage of Malaysian case, my lord. Stating this based on the facts of the case of Haverty Furniture Co. against Faust case, which is a Tennessee Court of Appeal case, it is stated, courts in other jurisdictions, both federal and state, that have addressed issues involving civil intra-corporate conspiracy allegations have adopted that the wholly intra-corporate conduct does not satisfy the plurality requirement necessary to establish an actionable conspiracy claim, my lord. And moving forward, a basic principle of agency is that a corporation can act only through the authorized acts of its corporate directors, officers, and other employees. Thus, the acts of the corporation agents are attributed to the corporation themselves, my lord. So merged together, it can be clearly seen because the law requires two or more persons or entity to have a conspire, a civil conspiracy is not evident in our current case and legally possible where a corporation and its alleged co-conspirators are not separate entities, my lord, but instead stand in a principal-agent relationship. Coming to the second point, my lords and my lady.
What you just said, can you elaborate what you mean? Who is the principal and who is the agent?
In our circumstances, my lord, in our case, we are stating that this is a separate legal personality where this separate legal personality does not have any involvement to do with the intra-corporate conspiracy doctrine, because the intra-corporate conspiracy doctrine clearly states that as long as the agent is acting within the scope of his or her authority, the agent and the corporation are not separate entities and cannot be sole parties to a conspiracy, my lord.
So are you saying that Grey Eye is the agent, or the company is the agent, or the company is the principal?
I'm sorry, my lord. I think I've been cut off.
Oh, okay. Can you hear me?
Yes, my lord. Now, yes.
Yeah,
sorry,
I just wanted clarity on this. So I understand what you're saying, that for conspiracy, you need two or more. In order for there to be a conspiracy, you can't have a conspiracy with yourself.
Yes, my lord.
And you are then saying that there are no two or more persons for the purposes of the cause of action of conspiracy here because of a principal-agent relationship.
Yes,
there
my
are
lord.
no two or more principals, you're saying?
Yes,
my
my
lord.
lord.
What you're saying?
Yes.
Okay. So my first question is, which party or entity is the principal?
The principal will be Grey Eye, my lord, in this current
Grey Eye.
circumstances. Yes,
So are you saying that the directors and the shareholders, Elon, Tony, and Mark, are the agents?
yes, my lord.
I see. Okay. Carry on. I just wanted to clarify that. Yeah.
No problem, my lord. Moving on, as I've stated before, indeed, it is in the scope of employment exception that prevents the intra-corporate conspiracy immunity doctrine from being applied too broadly. And this clearly because we can see in our case, for a claim of intra-corporate conspiracy to be actionable, the complaint must allege that corporate officials, employees, or other agents acted outside the scope of their employment and that they engaged in conspiratorial conduct to further their own personal purposes and not those of the corporation. And if I may strengthen my argument, my lord, I would cite the case where I would say in our current case, to continue with my submission, I would say in our current case, the piercing or lifting the corporate will not be in the favor of respondent in today's proceeding, as it has been laid down in the case of Ong Leong Chiao and Anor against Keller M. Sundram Berhad and others, which is a High Court case, but then re-appeal. It is clearly stated if the respondent is in the view that principle of intra-corporate or if piercing or lifting the corporate will be in favor of them, we are totally disagreeing to this because it is clearly cited. However, the federal court cautioned that Lord Sumption's analysis should not be applied rigidly, as this risks unduly limiting the situations in which the corporate will may be pierced. Additionally, the federal court also agreed with Baroness Hill in the case of Pest against Petrodol, which is a court of bill case, that where will piercing is used to convert the liability of the controller of the company to the company itself, the utilization of the agency concept and the directing mind will be more appropriate than the doctrine of piercing of the will. My lord, if there is no further clarifications on my first issue, I would love to proceed to my second issue of my submission, if I may.
Yes, please.
Thank you, my lords and my lady. Coming to the second issue of my submission, whether there was an appropriate circumstances for the High Court to award exemplary damages. My lords and my lady, in the current proceeding, the counsel for the appellant would argue that exemplary damages were only to be awarded in special circumstances, which can be derived from Lord Devlin's speech in the case of Rooks against Barnett. In the current case, my lords and my lady, the award for the exemplary damages is too high, as the amount of damages awarded is disproportionate with the amount of profit that the respondent assumes to be all theirs. This is because the exchange of 2% of the profit will only be $5 million out of $215 gained by Grey Eye, my lords and my lady. Clearly, if we seen from the quantum of the amount of the exemplary damages awarded by the High Court, it is not proportionate in our current circumstances, because the profit made by Grey Eye is 250 million, and that in our current circumstances, the profit, the exchange amount or the exchange rate of amount should be only $5 million, my lord. If we see 2% exchange rate from the agreement made, we actually fulfill 6 times of the exemplary damages, which is too disproportionate and too high, where we are in the view that 3 times of the amount would be proportionate, which is $15 million instead, my lord. In addition, if I may strengthen my argument, my lord, this can be seen in a Malaysian case itself, where there could be no categories as of the cases list by Lord Devlin had now been settled in the decision of House of Lords in Counsel and Co. Limited. So the Court of Appeal in the current case that I'm about to submit is in the case of Sambaga Valley. This court also made the following observation. Before departing in the very last line of the submission itself in the Sambaga Valley case, it is clearly stated, we would like to emphasize again that exemplary damages are not intended to compensate the plaintiff and are not recoverable as a matter of right, my lords and my lady. The amount of the exemplary damage award is literally left to the discretion of the court, and it can be seen that considering that this amount have also need to be appropriate to the current proceeding, we are stating that this amount is uncontrolled and arbitrary because the minimum necessary to achieve their purpose in the context is not clearly proportionate. And if I may cite again, my lord, Lord Devlin in Rooks against Barnett, cited in the case of Tetuan Kana and Co., sued as a firm against Saling bin Lau, Cheang and others appeal in 2019. It is stated in the line itself that the power to award exemplary damages constitute a weapon that, while it can be used in defense of liberty, can also be used against liberty, my lords and my lady. And with reference to the, yes, my lord.
Counsel, can I just ask you there? So you accept that exemplary damages are in the discretion of the courts, namely in the High Court in this instance?
Yes, my lord.
You are saying that there should be some basis, nevertheless.
Yes, my lord.
Do you accept that exemplary damages are awarded when the court is of the view that a party has misconducted themselves?
My lord, I understand your concern. However, in our case, we would say there is no serious conduct because the alleged co-conspirators, the conduct of transferring the money is actually to the subsidiaries company, which is a separate legal entity in our current case. And being said that, if I may refer, my lord, with the reference to the case of TAS Logistics, Sundram Berhad against TAS Matters Sundram Berhad, in 2020, Daryl Gun J cited in the English Court of Appeal case of Ramzan against Broadway that there is little guidance on quantification of exemplary damages, but clearly the sum must be principled and proportionate, my lord. However, in the current proceeding today, we find that this is disproportionate because the amount of exchange that should be given from the profit is only $5 million, my lord. And in the current proceeding, the High Court is awarding $30 million, which is 6 times the amount that should be given back to the respondent in the current case, my lord.
So, Counsel, can I just ask?
Yes, my lord.
The reason why the reason why the High Court judge gave exemplary damages is because he found that the conduct of the persons involved were abhorrent, right? Unreasonable, right? Is that correct?
Yes, my lord.
Yeah. So you are saying that in the circumstances, it was right for the judge to, his decision to award exemplary damages is within his powers, within his authority?
It is clearly said already in the High Court, my lord. However, we find that this is a point of view in the current proceedings.
That's yeah. So would you agree with me that your position is that it was within the jurisdiction or the authority of the judge to award exemplary damages? Is that correct? As a principle? Yeah. But you're just saying it's too much. Is that right?
We are saying that if, I'm sorry, my lord, I would, if I may ask for additional time because my time is up for me to wrap up.
Yes.
Thank you, my lords and my lady. So clearly, I'm sorry if I may lead the counsel for today's current proceeding. However, we would say that this is not principle. Even though it is on the judge's discretion, it should be principled and proportionate. And even
so you're saying it's too much, right?
Yes, my lord.
So you're saying it's too much. What he ordered by way of exemplary damages was far in excess of what was necessary.
Yes, my lord. Yes, my lord.
So you're saying that the amount that he should have ordered is how much?
I would say the amount awarded should be $15 million, my lord, which is only 3 times.
How do you come to that though?
Because
how do you come to 3 times?
My lord, because the current circumstances is that we need to award the exemplary damages as in 6 times. And we are in the view that it will be proportionate. It is only if it is 3 times over than the current amount, because 6 times
I understand.
Yes,
I understand.
my lord.
But I just want to understand why you say 3 instead of 6. How do you get to 3 instead of 6?
Because it is totally disproportionate in the current proceeding, my lord. Because the exchange.
I know, but how do you measure proportionality?
It can be clearly cited in the case of Sambaga Valley itself that 25% of 25% should be the required amount for the exemplary damages to be so. And however, in our current case, it is not clearly foreseen, my lord, because this is totally not principled and very disproportionate, my lord.
Okay, thank you very much.
Thank you, my lords and my lady. So if I may strengthen my argument for today, in the current case, the award for the exemplary damages is too high as the amount of damages awarded is disproportionate with the amount of profit that the respondent assumes to be all theirs, my lords and my lady. Even if the credit facility is added to the amount, the most damages that should be given to the appellant would be 18 million and not as if $30 million, my lords and my lady. And before I end my submission today, my lords and my lady, the counsel for the appellant strongly stands firm with our stand that we out Grey Eye and its directors, Tony, Elon, and Mark, to not be held collectively liable, and that the amount of exemplary damages awarded is not appropriate and disproportionate to our current case based on the facts laid down by the counsel for the appellants. With that, I rest my case, my lords and my lady. Much obliged.
Thank you very much, counsel. Are the counsel for the respondent ready to address us?
Certainly, my lord. My lords and my lady, before I begin, may I just confirm that I'm audible and visible?
Yes, you are.
Much obliged, my lord. May it please this honorable court, my name is Chua Kai Shin, the lead counsel. Together with me is my co-counsel, Ms. Chen Wei Lin. By appearing before this Court of Appeal on behalf of the respondent, Oracle. I will be submitting for 21 minutes on the first and second procedural issues concerning whether the latter can be adduced as further evidence to the Court of Appeal and whether the latter should be admissible as evidence in light of Section 733A of the Evidence Act 1950. My co-counsel will then be submitting on the remaining issues for 22 minutes, and we humbly reserve 2 minutes for the sole rebuttal session. My lords and my ladies, as for the first issue, the respondent submits that the letter provided by the anonymous whistleblower can be adduced on appeal to the Court of Appeal pursuant to Section 69, subsection 3 of the Court of Judicature Act 1964 and Rule 7, sub-Rule 3 of the Rules of Court of Appeal 1994. My lord and my lady, as correctly pointed out by my learned friend, the special grounds as prescribed under the section mentioned earlier are referring to the Federal Court landmark case of Lau Fusan and Government of Malaysia, which derived from the Ladder Marshall case, which held that 3 conditions must be fulfilled in order to satisfy the court in order to admit the further evidence during the appeal. The 3 conditions are: first, the evidence must be shown that it could not have been obtained with reasonable diligence for use at the trial. Second, it will probably have an important influence on our outcome of our case today. And although it need not to be decisive, and last, the evidence must be apparently credible, although it need not to be incontrovertible. Yes, my lords and my lady, the respondent today will then prove to this honorable court that all these three conditions has been satisfied, and the letter should be adduced to the Court of Appeal as further evidence. Before going into the first condition, my lords and my lady, the appellant in their submission just now contended that the source is unknown and this should not be adduced as further evidence. However, my lords and my lady, the respondent would like to highlight that the source of the evidence is irrelevant for us to adduce the further evidence. What is more important here is that as long as the respondent is able to satisfy the court with all the three conditions, the letter should be adduced as further evidence. My lords and my lady, as for the first condition, the appellant contended that the respondent failed to obtain the letter with reasonable diligence. However, this condition is not about whether the respondent had exercised reasonable diligence, but whether the letter is possible to be obtained by reasonable diligence. The respondent then submits that the letter could not have been obtained with reasonable diligence for use at the trial at the High Court. My lords and my lady, our argument is twofold. First, my lords and my lady, if I may refer this honorable court to the case of Hui Ni-on and Chai Wen-shin, in this particular case, the respondent had filed an application to adduce further evidence establishing that the association was the registered proprietor of the land. And when it comes to the first condition on whether the relevant evidence should have been obtained with reasonable diligence, the court deliberated that due to the basis that the registration of the transfer was not available at the hearing before the High Court, and it only occurred after the High Court order. It was concluded in this case that the evidence could not have been obtained with reasonable diligence by the respondent. Back to our case today, if I may refer my lords and my lady to the moot problem, page 4, paragraph 16. Is my lords and my lady with me?
Yes.
Much obliged. This paragraph says that the letter only came from the whistleblower when the case was pending the appeal to the Court of Appeal. Thus, the respondent submits that even if respondent had exercised reasonable diligence, it is undeniable that the letter cannot be obtained as it is only provided by the anonymous whistleblower when the judgment was delivered and concluded in the High Court.
But I don't understand, counsel, why do you say, I think there's no doubt as to the timing as to when the respondent applicant got to know about this letter. But I'm just wondering, why is it that you didn't come across this letter earlier just before trial in the High Court when there is the usual discovery process?
My lord, we understand your lordship concern, and the appellant also contend that the discovery application should be done by the respondent as necessary step to obtain the letter. However, my lord and my lady, a discovery application can only be done if the party is able to request for the specific document and not the letter in this case, which is much more general. Thus, the appellant don't even know that the existence of this letter, and if the respondent were to apply for the discovery, the respondent will be deemed as fishing expedition, my lord. My lord, to strengthen our position regarding the first condition, we understand that the appellant says that the letter in fact exists before the trial. However, whether the letter exists before the trial is immaterial to our case today. Because if I may refer your lordships and my lady to the moot problem, page 4, paragraph 16. Is my lord and my lady with me?
Yes.
Much obliged. My lords and my lady, the letter is provided by a whistleblower who is a person from GI itself and not an outsider. Thus, if I may cite the case of Mrs. Segar Sendirian Berhad and Silver Concept Sendirian Berhad, the court held that when an evidence can only be obtained with reasonable diligence when it is available at any public domain. However, my lord and my lady, it is not our case today. The evidence, which is the letter, is between a parent company to its subsidiary company, which is definitely a private, confidential, and undisclosed letter. Most importantly, the letter is not available at any public domain. This on the basis that the letter only come to the attention of the respondent after the trial have been concluded at the High Court, and it doesn't exist at any public domain. It is our position that it could not be obtained with reasonable diligence by the respondent.
I think, Counsel, I think
Yes, my lord.
if you could address us, what troubles me is this allegation that the letter is a fabrication because the letter is purported to be dated 1st of June 2020 on the letterhead of Gray I, signed by Marcel as the CEO. But I think it is an undisputed fact that Marcel ceased to be the CEO of Gray I 1.5 years before the date of this letter.
If I may clarify this, my lordship, concerning about the credibility of the letter, because given
yes,
that
yes, the credibility of the letter.
certainly
Because that is what your learned friend, Mr. Lim, has stressed to us, that on the face of it, based on the undisputed facts, it is clearly not a credible document. Can you address us directly on that?
certainly we'll be addressing the issue of credibility, my lord. My lord, if we construe the condition of apparently credible, it is in fact not required for the respondent to prove that the letter is undisputed at all, which means the threshold for this apparently credible is relatively lower. If I may cite the case of Mutual Development and Construction, Sdn Bhd, and Seisaki Malaysia, Sdn Bhd.
Sorry, can you say the name again, please?
My apologies, my lord. Mutual Development.
Mutual
Development.
Mutual Way Development. Okay. Yep.
And Construction, Sdn Bhd. And Seisaki Malaysia, Sdn Bhd, my lord.
Yep.
My lord, much obliged, my lord. My lord, in this particular case, the court, in determining the credibility of the letter, the court had held that the evidence is considered apparently credible when the evidence at first glance seems to be inherently probable and credible. And my lord, the letter today is with the full letterhead, stamp, and signature from Marcel itself. So any reasonable man at first glance will seem that it is an apparently credible evidence, my lord. My lord, back to the second condition concerning if there's any important influence with our outcome of our case today. Before I proceed, does my lord require any assistance and further clarifications?
No, I just, clarification in the sense that you are saying that the test as to whether this letter is credible or not is a low threshold test, and all we need to do is just look at it on its face.
Yes, this is one of the tests have been adopted by the case of Mutual Development.
But we can't ignore the allegation though that the supposed author of this letter was no longer an employee at the time.
My
How
lord,
do you suppose we overcome that?
my lord, in addressing your lordship's question, if I may again direct this honorable court to the corrections and clarifications, page 3, paragraph 4. At the sentence 3, at the third sentence, we can see that it is the appellant position or the contention that Marcel was the CEO who has been terminated. And in fact, this is not the facts of our case today. It is merely their contention. And in this regard, the respondent would like to refer this honorable court.
Hang on, slow down. Let me
Certainly, my lord. My apologies. My lord.
look for the document.
My apologies, my lord. If I may refer this honorable court to the corrections and clarifications.
Yeah, I seem to have misplaced the document. There are just too many documents.
Much apologies, my lord, for the rushing.
Yes. So what are you saying?
Page 3, paragraph 4. At the third sentence, it says that appellant had contended that Marcel was their previous CEO who has been terminated in 2019. However, my lord, the respondent position is that it is the mere contention of appellant and it is not the real facts of our case. And in this regard, the respondent would like to refer this honorable court to the case of public prosecutor and Datuk Sri Muhammad Najib bin Haji Abdul Razak. in this particular case, my lord, the court held that it is very common for the business practice to have a signature being cut and paste as long as the signatory possess knowledge. And my lord, we are aware that the incorporation of Grey I, Grey Matter, and Grey Corp was after Marcel left company. However, my lord and my lady, the incorporation of company is not a simple decision and it requires a long time and effort. Thus, we submit the respondent position is that Marcel, as the main core of the company, ought to know that there's an incorporation of the companies. Additionally, my lord, in fact, there are precedents of transfer money from Grey I to its
Counsel, just a clarification.
Yes, certainly, my lord.
I think the timeline or the chronology is such that Marcel is alleged to have been terminated as the CEO and left Grey I even before the contract with Oracle.
Precisely, my lord.
And that Grey Core and Grey Matter were established after the contract.
If I may direct this honorable court to the moot problem, page 1, paragraph 5. In fact, this company were incorporated in December 2019, but the facts doesn't show that the subsidiary will in fact exist before the incorporation. And the respondent position today is that the master who is as the core position in the company, they ought to know that there's an incorporation of these three companies, and thus he ought to possess the knowledge of the latter, my lord.
Sorry, can you repeat what you just said?
Certainly, my lord. My lord, if we look into paragraph 5, there's nothing to say that the subsidiaries of Grey Core and Grey Matter only exist in December 2019. In fact, they only incorporated in December 2019, which means these two subsidiary company in fact already exist at the first place. And since that incorporation is require a long effort and time, Marcel, who is the main core of the company, ought to know that there's an incorporation between this parent company and its subsidiary company. And it is the respondent position to submit that.
Counsel.
Yes, my lord.
The paragraph 5, the last sentence says that these companies were incorporated in December 2019.
Precisely, my lord.
So Marcel is alleged to have left in January of 2019.
Yes. However, my lord, these two subsidiaries might exist before their incorporation, my lord.
On what basis are you saying that?
Because there's nothing from the moot problem saying that the subsidiary company only exists after Marcel being left the company. Because the December 2019 was in fact the incorporation date and not the existence of this subsidiary company, my lord.
So how does the company exist?
There's nothing shown in the moot problem, and it is the two subsidiary company exist before Marcel left the company. It is the respondent position in this regard, my lord.
So, Counsel, are you saying that despite the fact that those companies had not been incorporated, because they were only incorporated in December 2019,
yes,
despite that, you're saying that they had existed in some other capacity or in some other form? Is that right?
Yes, my lord, because since that Marcel is one of the high position in Grey I, he ought to know that this company is going to cooperate. Because when we talk about incorporation of company,
okay, that's what I just want to clarify one thing. You're saying it had not been incorporated, but it was going to be incorporated.
Yes, my lord. That's the response.
And on that basis, it had existed.
Yes, my lord.
Okay. Is there an authority which says that a company that is going to be incorporated but had not been incorporated is an entity?
My lord, if I may again refer my lordships to paragraph 5, first sentence. First of all, it says that Grey I also wholly owns two subsidiaries, namely Grey Matter and Grey Corp. And regarding the timeline of December 2019, it's deal with the incorporation and not the existence of this subsidiary company, my lord. My lord, if my lord would like to listen to the submission for the second condition of important influence.
Okay, go on.
Much obliged, my lord. My lord, as for the second condition concerning the evidence that would have probably an important influence on the outcome of the case today, the respondent would like to refer this honorable court to one of the cases decided by this court, which is Malayan Banking, Berhad, and Sparrows and Arrows, Sendirian Berhad, and others. It was held that the appellant fulfilled the second condition when the evidence showed that it was contrary to the position taken by the respondent in this particular case. My lords and my lady, the respondent submits that the letter would have probably played an important influence on the final decision and outcome of our case today. This is due to the letter containing the main facts and details substantiating the appeal of the alleged conspiracy by the appellant. The contents of the facts serve as evidence to show that there's an agreement and consensus between the directors in Grey Eye on how are they going to siphon the money from Grey Eye to Grey Matter by utilizing the name of R&D. This is totally contrary with the position adopted by the appellant, contending that there's no conspiracy was happening between the directors and Grey Eye. Thus, the respondent submits that the second condition to adduce the letter as new evidence is satisfied on the ground that the letter had an important influence on the outcome of our case today, and it need not to be decisive, my lord. My lord, if there's no further assistance to first issue, the respondent will then proceed to second issue.
Yes, please carry on.
Much obliged, my lord. My lord and my lady, in regards to the second issue concerning whether the letter is admissible in light of Section 73A of the Areas Act 1950, it is tried law established in the case of Arab Malaysian Merchant Bank Berhad and Chong On for Medical Hall and Liquid Dealers that under three circumstances in which the document will be rendered admissible to the court by which is Section 73A. First, in admitting any document as evidence, the maker of the statement is called to give evidence by Section 73A, subsection 1, subsection B. Second, the maker is not available, but the proviso to subsection 1 is satisfied. And thirdly, where the maker of document is available but was not called as a witness, given the circumstances provided under subsection 2 has been satisfied. And my lord and my lady, the main contention of the appellant put forward today is saying that the respondent had failed to obtain the next any evidence. Nonetheless, the respondent humbly submits that the letter issued by Marcel can be admitted to the court under both Section 73A, subsection 1, and or subsection 2 of the Evidence Act 1950. We have two main grounds to rely on. First, the letter is admissible as the maker of the document, Marcel, can be called to give evidence, my apologies. And second, the court can admit the letter even if Marcel is not called to the court to give any evidence. My lord and my lady, as for the first ground, the letter is admissible under Section 73A, subsection 1, as Marcel, who possesses personal knowledge of the matters dealt with by the letter, can be called as a witness. My lord and my lady, as we can see in the corrections and clarifications, page 3, number 4, it is clear that Marcel, who held the high position of CEO in Grey Eye, and he was the one who signed the letter. Is my lord and my lady with me?
Yep.
Much obliged. Thus, by inferring from the circumstances and also the ought to know that the incorporation of this company, it indicates that Marcel possesses knowledge of the matter dealt with by the letter, and he should call to the court to testify on the letter issued by himself to Grey Matter. Therefore, yes,
Cheang, time is up.
You can take 2 minutes to wrap up.
Much obliged, my lord. My lord, nonetheless, it is the respondent position that if this honorable court view that undue delay and undue expense might be incurred if the maker of document were to be called to give evidence, or to avoid any undue delay or undue expense caused to this proceeding today, the letter still can be admitted to the court under Section 73A, subsection 2, without calling the maker of document. My lord, this simply means that the maker of statement could be dispensed with if the calling of the document to testify in court, which might cause any some unnecessary undue delay and expense, as one of the landmark case, Arab Malaysian Merchant Bank Berhad, in which the court viewed that the makers of the document had left the company and could not be traced. Thus, the court in that case viewed that if the court were to call upon this, the maker of document, it would mean further postponement to the case, which might cause unfair to every party. My lord, the appellant also contend that there's no effort has been done by the respondent in searching for Marcel However, we humbly submit that it's merely the assumption as the facts is silent on that matter, my lord. This, my lord, by applying the tried law as aforementioned, the court will have the authority to admit the letter if the this honorable court view that undue delay and undue expense might be incurred if the court were to call upon muscle. To conclude the respondent's submission on first and second issue, the respondent pray that this honorable court to adduce the letter as further evidence as it satisfies all the three conditions. First, it is credible, apparently credible. Second, it would not have been obtained with reasonable diligence during the High Court trial. And last, it would have an important influence to our outcome case today. And for the second issue, we humbly pray that the letter is admissible under section 73A, under subsection 1 or subsection 2, as all the requirements has been fulfilled. Should there's no further assistance to this honorable court, the respondent, I will now yield the floor to my co-counsel to submit for the following grounds. Much obliged, my lord and my lady.
Thank you.
Thank you.
Much obliged.
Before I begin with my submission, may I confirm if I'm audible and visible?
Yes.
Yes.
Much obliged. May it please the court, my name is Cheang, reading on behalf of the respondent. I'll be speaking for the next 22 minutes with regard to the third issue on the unlawful means of conspiracy conducted by the appellant, and the fourth issue on the appropriateness of awarding exemplary damages in this case and the quantum of such damages. My lord, my ladies, with regard to the third issue, the respondent's stance is that Grey Eye and its three directors, Elon, Tony, and Mark, ought to be held collectively liable for conspiracy. Before I begin with my submission on the conspiracy, I would like to first refer this court to paragraph 19C of the moot problem, where it stated clearly that discussion should be made with reference to the applicability of the intra-corporate conspiracy doctrine, which the appellants are supposed to submit that this principle is applicable because, as pointed out by my learned friend, this principle of intra-corporate conspiracy under the American law provides that a company and its employees are of a single entity, and hence it is impossible for the directors and Grey Eye to conspire with themselves, which will actually support their stand as to no conspiracy will be conducted in this case, since Grey Eye and its directors were operating as a single entity. However, our learned friend has stated that this principle is inapplicable, which is in our client's favor, because under the separate legal entity principle, Grey Eye and its directors will be able to conduct an unlawful means of conspiracy. Hence, my lord and my ladies, under this issue, we have two grounds to submit. First, the principle of intra-corporate conspiracy is inapplicable in this present circumstance. Secondly, there is an unlawful means of conspiracy by Grey Eye and its directors. And with regards to the applicability of the principle of intra-corporate conspiracy, our submission is on two folds. Firstly, this principle is an American principle. Secondly, this principle is in contrast with the established separate legal entity principle in Malaysia. The respondent is well aware that there are instances of this court accepting American law. However, I would like to refer this court to the case of Inter-Maritime Management Sdn Bhd and Kai Tai Timber Co. Limited Company, where the court had pointed out the important differences that exist between Malaysia and any foreign jurisprudence should always be borne in mind when it comes to deciding whether to incorporate the foreign principle into our common law. And it is also pointed by courts that it is prudent to approach American law and authorities with caution. For instance, in the case of ASEAN Bankers Malaysia Berhad,
Counsel,
yes, my
Counsel,
lord.
just to save you time, we accept your proposition. Assume that we accept your proposition that a company and its officers, for example, directors, under Malaysian law are not necessarily taken as one and the same entity. Assume that, please address us on the facts of this case, whether or not the intra-corporate conspiracy allegation and cause of action can be applied.
If I may clarify, my lord, you're asking if this principle can be applied in this present circumstance.
Yes.
Our position is that no, because it is opposed to the Malaysian law, which provides that companies and its directors should be regarded as separate legal entities. This has been codified under Section 20 of the Companies Act and also had been decided in the case of Law Cum Loy and another by Baltic, Sendirian Berhad and others by this court. And hence, in such a situation where the foreign law is as opposed to the current law we have in Malaysia, we submit that this court should not be applying the principle of intra-corporate conspiracy. And on top of that, my lord, we would like to highlight the fact that the application of this principle will actually create a blanket immunity for all forms of conspiracies, because any director can then rely on this rule and use their company as a sham to carry out fraudulent actions. Thus, we urge
Can I ask you, your learned friend, I think Chick City, had submitted that in a relationship of a company with its directors, the company is the principal and the directors its agent. Can you address us on that proposition?
my lord, that is under the agency law, where we will say that a corporation can only act through its agent. However, since in this case, the issue concerns conspiracy and under company law, we would urge this court to refer to the Companies Act. And under the company law, it is a tried law that a company and its directors should be regarded as separate legal entities, my lord. And hence, it is for the reasons mentioned, we urge the court to uphold the High Court's decision that the principle of intra-corporate conspiracy cannot be applied in this present case. Having established that, I would like to submit that Grey Eye and its 3 directors had conducted an unlawful means of conspiracy to defraud, as all 3 elements have all been fulfilled. And just for clarification to this court, my learned friend just stated that the 3 directors were under grey matter and grey call. However, my lord and my ladies, if I may take your attention to paragraph 4 and 5 of the moot problem. It was given that Grey Eye was founded by its 3 shareholders and directors, Elon, Tony, and Mark. And under paragraph 5, it is given clearly that grey matter and grey call are managed by their respective board of directors who have no connection with Grey Eye's board of directors. And hence, these 3 directors are merely under Grey Eye, my lord and my ladies. And before we submit on the thought of conspiracy, the respondent would like to highlight that an appellate court has to take into account the advantages enjoyed by the trial court in hearing and seeing the witnesses. When the question of fact has been decided by a judge and the appellants fail to prove that the judge had misdirected himself, the appellate court should not be coming to a different conclusion. And since in our present case, the High Court had held that there is no conspiracy at all after the trial, the appellants bear the burden to prove that the High Court judge had in any way misdirected himself, which they have failed to demonstrate to this court. And our submission is that in this case, there was indeed a conspiracy because, as I mentioned, all 3 elements have been fulfilled. First, there was an agreement between Grey Eye and its directors. Second,
Sorry,
actions.
you said there was an agreement between Grey Eye and its directors.
Yes, my lord.
What is that agreement?
The agreement is concerning siphoning monies from Grey Eye to its group of companies, which has been reflected in the audit report. My lord, as
So
decided, yes, my lord.
You have characterized the capitalization by Grey Eye of its subsidiaries as siphoning. That characterization is not used in the audit report, is it?
My lord, if I may clarify your question, you're asking
No,
whether
you said that the agreement between Grey Eye and its directors, the evidence for that is found in the audit report, which states that Grey Eye siphoned monies to its subsidiaries.
Precisely, my lord. That is
Yes.
our contention.
Yes. Now,
Because
my question to you is the use of the word siphon is your characterization. The word siphon does not appear in the audit report, does it?
yes, my lord.
Okay.
And we will now submit on. Yes, my lady.
Young Ariff, we noticed that Young Ariff Lavinia has been absent for a while. Can you give us a moment to check up with her?
Oh, I see. Okay, sure.
Thank you.
Okay.
May I just confirm if my time will be stopped at this moment?
Yes, it will be stopped.
Much obliged.
Hello everyone, sorry for the wait. It seems like Young Ariff Lavinia is having some video technical difficulties. She has asked us to proceed with the round. Thank you.
Okay, thank you. So can we ensure that the time in between is not taken into account for Ms. Chen? And Ms. Chen, you can resume. Thank you.
Much obliged. Coming back to our submission, we acknowledge the fact that the siphon of monies is our contention, not a fact stated in a moot problem. However, my lord and my ladies, in the case of Renault SA and Innocom Corporation Sdn Bhd and another and other appeals, the Court of Appeal had said that an agreement is not limited to a sign and seal agreement. Any informal agreement, including a combination of efforts of the co-conspirators, would suffice as an agreement. And further, in the case of Deepak Jagishan, anak lelaki Jagishan Rozhan, and another, and Intra-Corporate Sdn Bhd, the court had said that it is sufficient if two or more persons combine with a common intention. And we submit that in this case, Grey Eye had conspired with its three directors to siphon monies or transfer monies from Grey Eye to its group of companies. My lord and my ladies, if I may invite your attention to paragraph 2 of the moot problem. The last two lines say that Grey Eye is a company that is able to generate huge amounts of profit. However, in this case, when Grey Eye had not made any profits for year-end 2020, its group of companies, inclusive of Grey Metal and Grey Core, had then made $250 million in profit. And if I may again take this court's attention to the clarifications item 13.
Yes.
Much obliged, my lord. It was given that the $250 million is also the profit that Grey Eye had made throughout the year of 2019 and 2020. My lord and my ladies, the standard of proof for this conspiracy in this case will be on a balance of probabilities, and hence we submit that there are sufficient facts for this court to make a reasonable inference that there was a common intention by Grey Eye and the three of its directors, and that the facts had shown that they had indeed caused damage to Oracle. On top of that, we are submitting that the agreement made was for the purpose to defraud Oracle. In paragraph 3 of the moot problem, it was stated that Oracle had offered Grey Eye $100 million of revolving credit facility. However, after almost 2 years they had given the 100 million, Oracle was not able to obtain any profits due to the unlawful means of conspiracy conducted by the appellants. And my lord and my ladies, in the case of the Kital Sendiran Berhad and Sarina binti Kamaluddin and others, the defendants had siphoned monies out of its companies, escaped its liability to pay the plaintiff its profit. The court was of the view that such actions had caused the plaintiff to suffer loss and damage. Similarly, in this case, Grey Eye, which siphoned monies out of its company to its group of companies, had brought damage to Oracle because Oracle was not able to receive any profits despite providing them a revolving credit facility of $100 million. And it is for the reasons mentioned that the respondent stands firm on our submission that Grey Eye and the three of its directors had conducted fraudulent acts. Before I proceed with my submission, does your lordship or your ladyship require any assistance from the respondent?
No, I'm fine.
Much obliged. Moving on
Yes,
to
I'm
the
good.
much obliged, my lord. Moving on to the fourth issue, the respondent submits that it was appropriate for the High Court to award exemplary damages, and the sum of $30 million was in accordance with established legal principles. The definition of exemplary damages is additional damages awarded with reference to the conduct of the wrongdoer to signify disapproval, condemnation, or denunciation of the wrongdoer's tortious act, and to punish the wrongdoer. The objective of awarding such damages is to display the court's indignant attitude towards acts committed by the wrongdoers. And Lord Devlin had then laid down the two categories of circumstances where exemplary damages could be awarded. We stand firm in our submission that it was appropriate for the High Court to award exemplary damages because our case falls under the second category, whereby Grey Eye's conduct had been calculated to make a profit for itself, which may well exceed the compensation payable to the plaintiff.
Counsel,
Yes, my lord.
I think the appellants appeared to accept that the court had authority and jurisdiction to make the order for exemplary damages, but the issue is that it was too much and it was not in proportion. So there is a proportionality issue here. Is that correct?
Precisely, my lord. And with regards to the quantum of damage, yes, my lord.
Yes. So why do you say that the award for exemplary damages in this case is justifiable or proportionate?
My lord, with regards to the quantum of damages awarded of $30 million, the appellants first contended that the appropriate amount should be 3 times of $5 million, merely because it was disproportionate to award 6 times of it. But she had then referred to the 25% principle laid down in the case of Sambaga Valley and Sikh family, and submitting that it should be 25% of the compensatory damages, which should be 11 million. Which, my lord and my ladies, these two amounts are contradicting with each other, and we will submit that 30 million was the correct amount to be awarded. Again,
Why?
My lord.
Can you address us on that? Why is it the correct amount?
Certainly, my lord. There are three factors laid down in the Sambaga Valley case as to determining the quantum of damages. First, it is the character of a wrongdoer's misconduct. Second, the nature and extension of the injured party's injury. Third, the means of the wrongdoer. And my lord, with regards to the first factor, the character of the appellant's misconduct, we will refer to the case of Television Broadcast Limited and others and Mandarin Video Holdings Sdn Bhd, whereby the court has stated clearly that a conspiracy to defraud is a serious offense. It is not like what the appellants contended, that it is merely transferring money to its group of companies. And in line with what Lord Devlin has said in Lucas and Barnett, the injured party can be properly awarded whenever it is necessary to teach a wrongdoer that tort does not pay. And hence, in this case, considering the fact that Grey Eye is a company that is able to generate huge amounts of profit, and then conspiracy to defraud is a serious offense, it was appropriate to award $30 million, my lord and my ladies. And coming to the second factor, the nature and extension of the respondent's injury. Oracle in this case is a bank that provides financing services in exchange for a share of the company's profit. Believing and relying on the fact that Grey Eye would be able to generate huge amounts of profit, Oracle had then offered them a revolving credit facility of $100 million, which Grey Eye had actually drawn out $44 million from the facility granted to them. And since the fact that Oracle had suffered damage in this case is not in dispute, it was definitely appropriate and necessary to award that amount of damages to the respondent, taking into account that Oracle had provided them a revolving credit facility of such a huge figure, my lord and my ladies. And coming to the third factor, the means taken by the appellants. There are two forms of conspiracy, lawful and unlawful means of conspiracy. And in this case, conspiracy to defraud falls under unlawful means of conspiracy. And hence, considering the fact that the conduct of the appellants in this case is of a serious nature and involves a huge amount of figure, we submit that there is a need for this court to set a good precedent in awarding exemplary damages to display the court's indignant attitude toward the acts committed by the appellants. Before I conclude my submission, does your lordship and your ladyship require any assistance from the respondent?
No, I'm fine, thank you.
Thank you.
Much
No,
obliged.
thank you.
Much obliged. Hence, it is for the reasons mentioned, the respondent submits that it was appropriate for the High Court to award that amount of exemplary damages by virtue of the existence of the unlawful means of conspiracy. With that, we humbly pray for this court to dismiss the appeal and hold that, first, the latter can be adduced as further evidence to the Court of Appeal. Second, the latter is admissible as evidence under Section 73A of the Evidence Act. And third, as contended by my learned friend as well, this principle of intra-corporate conspiracy should not be applied in this case because it is a foreign principle and it is as opposed to our current law in Malaysia. And hence, Grey Eye and its directors should be viewed as separate legal entities, and since they have fulfilled all three elements, the three directors and Grey Eye should be held collectively liable for an unlawful means of conspiracy. And with regards to the fourth issue, it was appropriate for the High Court to award exemplary damages, and by virtue of the three factors laid down in the Sambaga Valley case, it was definitely appropriate and necessary to award that amount of $30 million, my lord and my ladies. If I may no further assistance to your lordship and your ladyship, the respondent will now conclude our submission. Much obliged.
Thank you very much, Counsel.
Thank you.
Are we adjourning to the judge's room?
Sorry, Bushels.
My lords and my
sorry,
ladies.
Buttles. Okay,
Yes. May I begin?
yes.
All right. Am I both audible and visible to my lords and my lady?
Yes.
All right. Thank you, my lords and my ladies. May it please the court, I am Siti Nazatul Nadia, the second appellant that will be doing the rebuttals on behalf of the appellant. The counsels for the appellant will be doing our submission on rebuttals based on the submission and response to the respondent's submission. Clearly, first, it is stated by the first counsel for the respondent that they fulfilled all the statutory requirements, my lords and my lady, which is they said reasonable diligence could not have been exercised as the letter only surfaced after trial. Second, they also said the letter is of significant influence as it confirms facts. The third point is that they said that the letter is credible and source of letter is irrelevant, furthermore contending that the letter is signed, stamped, and in a letterhead. And lastly, subsidiary exists before incorporation. My lords and my lady, we submit as a response that it is not fulfilled. We would like to stress the date in which the letter is dated, being that the letter was dated on the 1st of June 2020, the letter definitely existed for long material times. Respondent had every opportunity to do so despite their allegation of it being a fishing expedition. Second point is that we submit that the facts were already perused and decided on said issue. Respondents adducing evidence is a mere afterthought and ought not to apply. Clearly, the third point, we submit that the letter being signed and stamped in the letterhead does not mean it is credible, because we would further stress that the letter is signed by a terminated ex-CEO, my lords and my lady. He either had no capacity to do so or his signature was forged. The respondents cannot just assert that Marcel is still an employee. They ought to prove their proposition. And lastly, we would submit that the company couldn't have operated whatsoever if the company wasn't incorporated in the very first place, my lords and my lady. Their allegations is a mere assertion, unsubstantiated with facts. Coming to the second point stated, Marcel can be called to produce evidence being said by the respondent. We are in response to this is that the fact of the matter remains that it was not done. Therefore, there is no support for any authentication of said letter. The third point coming from the respondents, my lords and my lady, is that the undue delay so as to avoid prolonged delay and extra costs. The onus is on them who seek to adduce evidence, my lords and my lady. The trust load is high and it needs to be satisfied. That is clearly on the grounds of the first appellant, first respondent, coming from the counsel of respondent, my lords and my lady. Coming to the point of the second respondent, she clearly contradicted her own argument because, my lords and my lady, we, the appellant, are required to contend all the issues to be answered in negative, which is why for us, the principle of intra-corporate doctrine should not be applicable. However, the respondents is in our stance saying that this is not applicable in their favor. As in in their favor, they're supposed to use it in the positive sense, my lords and my lady. And so they are actually contradicting their own submissions, my lords and my lady. Coming to the point that the definition of word siphoned, my lady. Siphoned meaning is a transferring of money, especially if it is illegal.
Counsel, can I just ask you?
Yes, my lord.
That point, I think that issue number 19C has been amended, right? So the original,
yes, my lord.
Yeah, the original issue was whether the principle of intra-corporate conspiracy is applicable in the present circumstance. And then that has been amended to say whether Grey Eye and its directors, Elon, Tony, and Mark, ought to be collectively held liable for conspiracy. And then discussion should be made with reference to the applicability of the intra-corporate conspiracy doctrine.
Yes, my lord. In addressing this question itself, we from the appellant ought to discuss all the issues that to be brought up in a negative sense, where there is no principle of intra-corporate doctrine. And clearly stated by our learned opposing counsel, Ms. Wei Ling, she's even cited the case of Sambaga Valley in her proceedings.
Mm.
However, in Sambaga Valley, my lord, in the very end of the submission in Sambaga Valley, it is clearly stated this word, my lord. Before departing, we would like to emphasize again that exemplary damages are not intended to compensate the plaintiff, my lord, and are not recoverable as a matter of right. And this is clearly seen in the case of Sambaga Valley, that the respondent clearly stated all the three requirements. However, she missed out the very last element, my lord. My lord, I see that my time is up. I would love to summarize my case.
Yes, please.
If I
please
may.
do. In 1 minute, yeah.
Clearly, my lord, thank you. My lords and my lady, they say there is a fraud, but did not prove the element of fraud in our case in the current scenario. If there genuinely is fraud, then where is the element being satisfied, my lords and my lady? So coming to the conclusion, my lords and my lady, before I end by submission, my lords and my lady, the counsel for the appellant strongly and stand firm with our stand that we out Grey Eye and its directors, Tony, Elon, and Mark, to not be held collectively liable, and that the amount of exemplary damages awarded is not appropriate based on the case cited by Lord Devlin in Brooks against Barnard, and even in Leong Cheang, which is a High Court case which is then reappealed. It is clearly stated it is not appropriate and disproportionate to our current case based on the facts that the counsel for the appellant has laid down, my lords and my lady. And with that, we will clearly strengthen the points that the letter is surely clearly and to be in the view of my lords and my lady in the current circumstances. With that, I rest my case, my lords and my lady.
Thank you very much, Counsel.
Much obliged.
Before I begin, may I confirm if I'm audible and visible?
Yes.
Much obliged. My lord and my ladies, with regard to the three rebuttals, we have 3 grounds to make. With regard to the third issue, the appellants contended that because the date was dated before the High Court trial, and hence the respondent ought to know that its existence. However, I would like to highlight the fact that this letter only came to our knowledge when the whistleblower produced this evidence to the respondent. Because in the same case that they have relied, my apologies, my lord, Maxis Serga Sanjaran Berhad, that letter was available at public domain, which is not what happens in this case, because this letter is a letter from a parent company to its subsidiary company, which Oracle, as an outsider, would never have known its existence if it's not the whistleblower. And coming to our third issue, my lord, if I may take this court's attention again to paragraph 19C, we acknowledge the fact that the appellants are supposed to contain all the issues to be in negative. However, the third issue is whether Grey Eye and its directors ought to be held liable for conspiracy, which means what they have to prove in negative is that there is no conspiracy in this case. And as pointed out by your lordship, that the both problem and issue had been amended, they indeed and in fact needs to submit that the principle of intra-corporate conspiracy is applicable to support their stand that there's no conspiracy in this case. And coming to the fourth issue, my lord, they were contending that the Sambaga Valley case said that the exemplary damages shouldn't be awarded in this manner. However, in that case that they have relied on, the court has said that there's no fixed rules and mathematical precision when it comes to assessment of damages, because the exemplary damages of the amount is left to the judge's discretion, and hence the fairness and reasonableness of the award cannot be subjected to any standard. And with that, we conclude our submission. And if I may no further assistance to this honorable court, the respondent will conclude our submission. Much obliged.
Thank you.
This honorable court is now adjourned. Judges will be moved into a breakout room for the scoring and deliberation session, whereas the participants are to remain in this room. Judges, please click Join Breakout Room once you are invited to the judges' deliberation room. Thank you.
Thank you so much,
Thank you.
judges, for your time. Thank you.
Thank you.
Thank you, my lords.
Thank
and my
you,
lady.
judges.
Thank you.
Thank you, counsel.
Thank you.
Thank you, bailiff and timekeeper, and our learned friends.
Yeah, thank you so much, Bailiff, timekeeper, and our learned friends.
Thank you
for a
too.
great match.
Thank you for a great match.
Do we need to keep our cameras off, or we can turn
You
them?
can
All right, thank you so much.
Thank you.
Thank you.
Thank you.
To those watching this live stream, please sit tight and stay tuned for the judges' comments. We will resume this live stream with the participants' feedback session once the judges have completed scoring and deliberation. In the meantime, please enjoy some pictures from the first 2 days of the competition. Hello participants, please get ready as judges will be coming in soon. Thank you.
We're waiting for, where did we lose Ariff? Oh, okay.
Hello everyone, and welcome back to the grand final round of Taylor's Intervarsity Mooting Competition 2022. We would now like to invite the judges to give their comments on the moot round.
Okay, thank you very much, all of you. I found it very interesting, actually. First of all, I found the moot problem very interesting in its straightforwardness and simplicity. It's unusual, actually, nowadays for a moot problem to be so concise. And I found that it was excellent. There were many layers to it. It left a lot of issues or things that the contestants could address. So it was very, very good. The other thing I want to say is with regard to the submissions that were made by all four of you, they were also very good. And I must say on behalf of the panel that it was a very close call. So by nature of a competition, there will be somebody declared as best oralist, some team declared as winning team. But from my perspective, and I think maybe it may reflect the thinking of my colleagues on the panel, actually there is no winner or loser. It's just on this particular occasion, a first amongst equals. That is all. And when I say on this particular occasion, I think Lavinia and Ariff would agree with me that very often, one, you are as good, a lawyer is as good as their case. Two, it depends on how you woke up that particular day. Whether you feel tired, whether you feel refreshed, and so forth. Yeah. So your wins and your non-wins come and ebb. That is not necessarily a reflection of you as counsel. Yeah. So please bear that in mind. So I think Lavinia and Ariff and I, we have some comments to make, and we are going to start off with Lavinia first. Lavinia.
Thanks, Chris. I'd like to say, yes, echo what Chris has said earlier. Very well done to all of you, all four of you. I'd just like to know, roughly, without mentioning the universities that you're from, are you in your first, second, or third year or final year? Second year, anyone? Third or second years? Oh, we've got 3 second years. And final years? No, third years?
I'm a first year,
Nadia?
miss.
First year, wow. So it's first and second years that we have. So well done, extremely well done. I would have thought you were in your final year. So we can see from your level of your advocacy, the confidence that all of you have. I must say that all of you had very good structure to your submissions, very good pace. We were able to follow your arguments, and you had a good structure in terms of you telling us where you're going to go, where you're heading. There was a roadmap through your submission, so that's very well done. I must say, one or two things that I would like to comment on is that, for example, if the facts and the evidence is not with you, or they're not in your moot problem, do not imply into it. You know, like, for example, someone was saying that it's not with, someone was saying that this fact is not with me, but we can assume or imply from this particular evidence or this fact that it was not written by so-and-so. So if it's not there, don't offer that information or that fact, because once you do that, or you invite that inference, and then you will invite all the questions. And I think it was Chris that went on to say, what do you say this? Why do you say this? What's your basis for saying that? So you just avoid being attacked by the judges or the panel. So don't even go there if it's not with you. Okay. And the other thing is to say is that if you don't have enough evidence to support the case that it is, for example, a forgery, so careful to use such words when you say, oh, it is definite that it is a forgery and therefore it is not admissible. Again, you invite, obviously, questions from the panel, such as, why do you say that? Is it only because that he was not in employment at that time? Because using such words such as forgery would, obviously be a higher burden. So you can, I suppose that comes with experience. So I'm just saying that, avoid those things so that there are not many questions from the panel as such, yeah. But regardless of who comes out a winner or not, all of you, well done. Don't forget that it's not just this moot that you will do. Keep doing it in your third year or your final year, and even when you get into practice, because advocacy is important, yeah. And it's just with perseverance that you would just keep becoming better and better. And that confidence that all of you have, I can see that not many of you are. I'm not sure whether you are actually reading a script online, because I'll never know now with online hearings. Probably it's there, but you're good eye contact, and you were listening to the questions, obviously. In live court, you know that there's only one person up there, and eye contact is very important. It goes to show your confidence. I won't be able to tell on Zoom, but I could tell by, you've been doing it from Friday, right? Thursday, Friday that you started. So I'm sure been many rounds. So I like your pace. Keep that with you. That's just the few comments that I just would like to make. So well done, regardless of who comes out a winner or not, or best oralist, all of you, extremely well done. And congratulations, all of you. That's all I have to say. Thanks.
Thank you, Ms.
Chris.
Lavinia.
Thank
You, Miss Lavinia.
Ariff?
Okay, hi everyone. Firstly, I have to commend all of you for the very hard work that you put into preparing for this moot. To me, it was obvious that many hours had been spent by all of you preparing your case. And I find it amazing that you had the time to do it as well as study. So well done. It was obvious from your knowledge of the facts that you had really spent a lot of time preparing. Congratulations for achieving such good results. One thing which I would say is this: if you know your facts really well, then my tip is you don't need to rely so much on your notes if you prepared them, because if you know your facts and you know your arguments really well, you sound much better when you speak naturally, without relying on your scripts. And trust yourself to know that you can articulate your arguments well and convincingly. So my observation is that your replies tend to be better than your original submissions, because you've not had time, you haven't prepared it, you haven't scripted it, and you're not reading off something. So when you reply to questions, or when you reply in your reply submissions, you sound more natural. And when you sound more natural, you sound more convincing, and you sound more credible, and your arguments are more attractive to the court, or to the arbitrator, or to the panel. But you can only do that if you know your case really well. And you can only do that if you know your arguments really well. But clearly in this case you do. Clearly in this case you've worked really hard. So rely more on your natural ability to articulate your arguments. It does sound more convincing, it does sound more credible. And it will connect you with the judges better. Because if you read from the script, no one's going to listen. And after a while, the attention span wears off, and then no one's listening to you. They're just listening to you read something. So that's just a little tip for when you move on to the future. I think all of you have excellent, advocacy skills, and it puts you in good grounds to become excellent dispute lawyers and dispute advocates later on. So I look forward to meeting all of you, maybe in court or maybe in arbitration one day. But be kind to me, when you're against me. Okay, but congratulations, well done, and good luck in your future. You really deserve the best.
Thank you so much.
Thank you, Mr. Ariff.
Thank you, Mr. Ariff.
Thank you. So my task, I think, is rendered less onerous, because I agree with everything Lavinia and Ariff has said. Actually, very good. I appreciate, actually, now after Lavinia has asked you all, when you put up your hands, what year you are at university. I appreciate it even more in terms of the quality that I have seen today. I just wish to just say very quickly a few pointers for each one of you. So I'll start off with Jonathan. Jonathan, it was very good. Your knowledge of the law and your application of it was very good. And in fact, between the two, the more important one is the application of the law. Comprehension of the law, and therefore applying it to the particular facts of your case. So that is good. I also like that you were able to answer, come up with an answer for my question regarding your submissions on Section 73, capital A of the Evidence Act. I don't know whether you recall, when you talk about the maker, calling the maker and so forth, and I said, we are no longer at the trial stage, we are at the Court of Appeal. So there will not be oral examination or testing of evidence. And then you quickly pivoted and said, yes, but they must at least produce an affidavit. For example, from Marcel. And so I thought that was a quick thinking. That happens. Well, it happened a lot in the past when there was an in-person advocacy. I know we're moving along slowly but surely to written advocacy. That is quite unfortunate from my experience, but that was good. I also appreciated that actually all of you, at least it didn't come across that you were reading. It's very important. It's very important because oral advocacy is really the art of persuasion. I mean, likewise with written submissions, but with written submissions, you have the luxury and benefit of time, and therefore of recrafting whatever you want to say, how you want to say it, but oral advocacy really is on your feet, and therefore what you call the fact that you are not reading, you're appreciating that it is really an art form. It is the art of persuasion on your feet, and that is important. Yeah, I think for City, I think you came across very clear. Your enunciation and your presentation was very, very good. you know, again, that underscores what I mean by advocacy, whether written or whether oral. Lawyers are really wordsmiths. You are supposed to be able to use the correct word, appropriate phrase, in the appropriate place, at the appropriate time, for emphasis and so forth, right? So you are wordsmith. There is no excuse not to be proficient in the language that you use for your advocacy. And I think Siti, you know, I really appreciated that. That was very good. Bear in mind, however, in your enthusiasm, do not overreach. So, for example, when I asked about the directorship of subsidiaries, and I think you said that they were also directors of the subsidiaries, but that is not a fact established. Now, that can come across in one of two ways. It can come across as, okay, you're not so familiar with your facts, or, and that would be, you know, that you can explain away, or it can come across as actually you're not being completely forthright with the facts, and that is something you wish to completely avoid. So bear that in mind. Yeah. Then for Chooi, I think the one thing that you did, which I appreciated, was when you introduced your case and the points that you're going to take, you set out the timing for yourself as well as for your co-counsel. Now that's very brave, because one of the things that judges in real life do is they will hold you to it. And so if you exceed it by substantially, you will irritate the judge. Yeah, so that is something not many lawyers voluntarily would initiate voluntarily. Judges will sometimes ask, how long are you going to take counsel? And then you have no choice. You have to give an indication. And then we try and couch it as a range. Yeah. So I noticed that you did that, but you did stick to your time. So that would, both you and your co-counsel. So that's very good. And then the other thing that I noticed that you did, as well as Ms. Chen did, was that after setting out what you are going to address and how you're going to address them, and then you made it a point that before I go there, I wish to address a point raised by my learned friend. Whatever that point is. Well, obviously it was a point that you thought was very important, and that's good, because in reality, you know, in the Court of Appeal, that's what happens. They want you to go straight to the point, and if you think that there is a difficult point for you raised by your opponent, and you wish to deal with that upfront, that is good. Or if you think that there is a point the other side raised or submitted on that is in your favor, you wish to underline it, underscore it, put it up in neon lights, and I think that's what Ms. Chen did. That is also very good. Yeah, and that is actually a skill which is taught, and I think Lavinia would know this, because Lavinia is an advocacy trainer. That is a skill that is taught in advocacy training. So that is a grade well above your level, and I'm very happy to see that you know you've done that. One thing that I would ask you to try and avoid, and that is in your submissions, to avoid using the word "it is trite." It is trite law, right? Because you're just telling the judge that, you know, this is it. This is what the law says. You are stuck with it. You lump it. You know, you must bear in mind that there are several levels of advocacy, as well as advocates. When you say something is trite, that is at a very basic level. Everybody can read up the law. They can read up when the law was established, when the locus classicus was pronounced, you know, and so forth. Remember always that you should strive not only to know what the law is. When you say it is trite, you should instead use well established, right? And that's what you mean when you say, when you know what the law is, but you should strive also to know what the law should be. And that is when you start arguing that a certain case should not apply, whether on the facts or on the law in principle. That means you're trying to distinguish a case. That is the next level, what the law should be. And then the third level is to be able to advocate what the law should not be. And you find that very often being argued in public interest law. Give you, for example, it may be beyond your time. Certainly it would be beyond Lavinia and Ariff's time. I'm the only one here that's old enough to know it, and that's on the ISA cases. So all of you are too young, but you know, the lawyers have had to argue for more than 4 decades against the ISA, against Supreme Court decisions, federal court decisions. And you know, sometimes you get your wins because you're saying to them, we know what the law is, and we're saying what the law should be, and certainly what the law should not be. Yeah? So just bear that in mind. And then on the facts of this case, I would have liked to have heard an argument that this is not really a case of siphoning of monies, the 250 million USD. This really at its core is a case of siphoning of a business. And the reason for why I say that is because on the facts in the moot problem, when Oracle entered into agreement with Grey Eye, there were no subsidiaries. And then in paragraph 2, it talks about the importance and success of Grey Eye's business, which is services of this niche area. There were no subsidiaries to research it, to implement it, market it, sell it. So all of it was done by Grey Eye. And then after the agreement with Oracle, you have these 2 subsidiaries. And if you look at your clarification, I can't remember which paragraph, it says that Grey Core undertook the research, R&D. Grey Matter did the marketing and business. So it poses the question, before these 2, then who did all of that? It was implicit in the moot problem that Grey Eye did it. So it wasn't really a hiving off of monies, because in the audited report, it says the monies were given to the subsidiaries for the conduct of their business. It's going to be very difficult to argue otherwise. It really is a case of hiving off of business. Yeah. So that I would have liked to have heard arguments on that. I leave you with a tip. You appeared in the Court of Appeal. In the Court of Appeal, in reality, the law is already known, especially if it is tribe law. So don't labor on the law so much. The judges of the Court of Appeal already know the law. They want to know the facts, how on the facts, right, read with the law. The facts as found, not the facts as you now say anew, but the facts as found, how that read with the law supports your case. Yeah. Okay, so with that, I wish to thank everyone. I wish to thank the Taylor's Law Society, Mooting Society, Taylor's Law School Mooting Society for having invited me, Lavinia, and Ariff to participate in this wonderful event. I want to thank all of the organizers in the society. Thank all the participants. Thank the 4 of you. Thank you very much. I'll pass this now back.
Thank you, Mr.
Thank you, Mr. Chris.
Thank you so much, Mr. Chris, for the input.
We will now proceed with the photography session. I'll pass it over to Ria.
So I'll be taking the photo. Everyone look into your camera and smile. 1, 2, 3. One more. 1, 2, 3. Please give me a moment while I look at the photos. The photos are good. Thank you.
Thank you.
Thank you. Thank you.
Are you going to send it to us?
Sorry, Ariff?
Please send the photos to us.
Yeah. Okay. Okay, wishing all of you the best. See you, Lavinia. See you, Ariff. Bye.
See you. See you,
Bye.
Chris.
See you, Chris.
See you, Ariff.
Thank you so much, judges.
Take care,
Good
everyone.
Good luck with all you
Thank you,
guys.
Ariff.
Well
Thank you,
done.
Miss
Thank you,
Bye-bye.
everyone.
Bye.
Bye.
Good luck.
We have now come to the end of the grand final round of Taylor's Intervarsity Mooting Competition 2022. For those of you who have joined us for the live stream, please sit tight and stay tuned as we will commence the closing and award ceremony momentarily. Judges, you may now leave the meeting or stay on this Zoom call to join us for the closing and award ceremony. As for the participants, please stay here for the ceremony later on. Have a nice day, everyone. Thank you.
Thank you, everyone.
Thank you, everyone.
Thank
Thank you.
Ladies and gentlemen, I would like to announce that the event will be starting shortly. To those of you who are joining us in this Zoom call, please ensure that your microphones are muted at all times. A gentle reminder as well that this event is being live streamed on YouTube. Thank you. A very good evening to Mr. Ariff Rozhan, Managing Partner of Ariff, Rozhan and Company, Ms. Lavinia, Partner at Lavinia, Valiant and Appellant Chambers, Mr. Hachran, Senior Lecturer and Moot Master of Taylor's Law School, judges, participants, volunteers, ladies and gentlemen. Welcome to the closing ceremony of Taylor's Intervarsity Mooting Competition 2022, organized by Taylor's Mooting Society and sponsored by Taylor's Law School, Ariff, Rozhan and Company, and Lavinia and Appellant Chambers. My name is Adrian Cheong, and I'll be your MC for this ceremony. To everyone on this Zoom call, may I kindly request, if it is appropriate for all of you, to turn on your cameras so that we can see your faces. Thank you. Now, to commence the closing ceremony, I would like to first invite Nimisha Teva, the President of Taylor's Mooting Society, to deliver her speech. Nimisha, over to you.
Thank you, Adrian. I want to start off this very short speech by first of all saying congratulations to all the mooters that participated in TIVC 2022. Whether or not you made it to the finals and whether or not you win an award, you all truly have so much to be proud of. Advocacy is always a difficult thing to do, especially so when it concerns an area of the law that we are definitely not exposed to in law school. I personally was able to sit in for some of the feedback sessions that we conducted with the judges, and many judges expressed how impressed they were with the standard and bravery of all the participants, and often mentioned that they likely would not have been able to do what all of you are doing when they were just law students trying to make it through law school. So congratulations to all of you, and I hope that Taylor's Mooting Society has done a good job of making TIVC a wonderful learning experience for all of you, and we hope that you will leave with very fond memories of this competition and all the sweat, the probably tears, and definitely the late nights that went into preparing for this competition. So as always, this speech would not be complete without acknowledging everyone that played a part in making it possible. First and foremost, Dr. Har Mahinda, Mr. Hacharan, and Taylor's Law School for always supporting our very big dreams and helping us achieve them, and for contributing to rewarding all of the mooters here with a very generous cash prize. Ms. Lavinia Kumarindran from Lavinia and Appellant Chambers, Mr. Ariff Rozhan from Ariff, Rozhan and Company for graciously sponsoring internship positions for the award winners of TIVC 2022, the judges for spending their weekends with us and challenging the mooters to do better round after round, the wonderful volunteers who have spent many a weekend with us, making sure that the competition runs smoothly, and thank God it did. The founder of Taylor's Mooting Society and a not so distant blood relative of mine, my brother Amitesh Deva, for drafting a brilliant moot problem that I'm sure all of our mooters thoroughly enjoyed. And last but not least, my wonderful board of directors, the organizing committee of TIVC 2022, Adrian, Eng Hong, Kelly, Xia Cheng, Utra, and Evelyn. Thank you for all your support, for being patient with my many, many demands, and for giving your all to make Taylor's Intervarsity Mooting Competition 2022 such a huge success. So I know my speech is not the main event that you're all waiting for, so I'm going to wrap it up with that and pass it back to Adrian. Thank you very much.
Thank you, Nimisha, for the very kind and heartwarming words. Next, may I invite Mr. Hachran Singh, Moot Master and Senior Lecturer at Taylor's Law School, to say a few words.
Thank you, Adrian. I didn't realize I was going to speak so early in the proceedings. So I'm totally unprepared. So Mr. Ariff Rozhan, Ms. Lavinia, ladies and gentlemen, that includes all the participants who are present now. I also address the participants who might not be present now. I include them in the rubric, ladies and gentlemen. Very good evening to all of you. Now, in my many years as a practicing lawyer, I discovered that it's actually quite foolish to try and follow a very good speech. But nevertheless, my training is that I still have to do it. So having heard Nimesha so eloquently put forward everything that I wanted to say, I'm now wondering what can I possibly add. So I'm not sure whether I should thank Nimesha for that, or should I actually take her to task for doing such a thing, making my task a lot harder. Now, pardon me, all of you, if I go ahead and repeat quite a bit of what she says. First of all, I would like to congratulate the winners. I would also like to congratulate all the participants who may or may not win other prizes. I would like to congratulate all the participants for one simple reason. And that is you have taken important steps towards your development as the future lawyers of Malaysia. Right? The future of the legal profession in many ways is in your hands. And advocacy in courts will remain one of the very most important aspects of the legal profession, despite what corporate lawyers may tell you. I apologize to any wannabe corporate lawyers here. I always insist that the most important aspect of legal knowledge, training, practice is litigation. I call it litigation. Dispute resolution. So what you have done in these past 3 days is to participate in a simulation of what you're going to encounter in real life. So congratulations, well done. Keep smiling, go forth and carry on mooting. Okay, don't give up. I need to say special thanks to all the judges. I'll start off by thanking the judges for the final round, Mr. Christopher Leong, Mr. Ariff Rozhan, and Ms. Lavanya. Thank you for taking time off. We wouldn't have been able to complete this competition without your presence. I, of course, also take this opportunity to thank those judges who are not with us today. Without whose help also, this competition would not have been complete. Thank you very much for that. Now, the TIVC is in its 3rd year of existence, and I believe we have grown from strength to strength, and that's largely, and in fact not largely, in fact it's entirely due to the tireless work that the Mooting Society board has put up. Okay, so congratulations, Nimesha, Adrian, Eng Hong, Kelly, Xiao Cheng, Evelyn, Udra, for doing a good job, wonderful job, if I may say so. The technical faults are not your fault, okay? You couldn't do anything about internet, whatever you call it, okay? Connectivity, yeah, that's the word for it. Now, I, of course, also would like to thank all the volunteers. Without them, this would not have been possible. All right, I think I've done enough of rambling, and you're not here to listen to me. You all must be on tenterhooks to find out who has actually won. Although I would end by saying that in my book, all participants have won. Thank you very much.
Thank you very much, Mr. Hatran. Now, without further ado, we will proceed to the part that everyone has been waiting for. I would like to pass it over to Nimesha to kickstart the announcement of the award winners. Over to you, Nimesha.
Okay, thank you very much, Adrian. So we're going to get right into it. We're going to begin with the award. Sorry if my slides will cooperate with me. For the top 3 best oralists of the general rounds. So we actually have 2 oralists tied for 2nd best oralists. Both these oralists will receive a 100 ringgit cash prize, graciously sponsored by Taylor's Law School. So the first oralist getting the award for 2nd best oralist is, with a total speaker score of 266 points, from Team 2002, Teng Yvonne. The second oralist, who also with a speaker score of 266 points, is the second best oralist for the general rounds. Wang Jinglin from Team 2015 from University Utara Malaysia. Moving on to the best oralist for the general rounds, also winning a 100 ringgit cash prize courtesy of Taylor's Law School, with a total speaker score of 268 points, is Chris Ng Xuet Yi from Team 2019, University Malaysia. Now, moving on to the big announcement. The champion who will take home a 500 ringgit cash prize courtesy of Taylor's Law School, as well as an internship position with Ariff, Rozhan and Company, is, drumroll, Team 2014, Chua Kai Sheng and Chen Wei Lim from University Utara Malaysia. And therefore, the runner-ups winning a 300 ringgit cash prize courtesy of Taylor's Law School, as well as internship positions with Lavinia and Balan Chambers, are Team 2013, Jonathan Joseph Lim Bing Yi and Siti Nazatul Nadia binti Muhammad Rizwan from Brickfields Asia College. Congratulations to all the award winners, the champions, and the runner-ups. And now, last but not least, the best oralist for the grand final, and this was a unanimous decision between all three judges, goes to, from Team 2014, Chen Wei Lin from University Utara Malaysia. And I forgot to mention it just now, but the champion and runner-up, the decision for that was actually a 2-1 split. So certainly a very close final and a very good grand final. So congratulations to all the award recipients. I'm going to pass it back to Adrian to walk us through the next part of the ceremony.
All right, that actually brings us to the end of the closing ceremony of Taylor's Intervarsity Mooting Competition 2022. Before we end, a quick request that all the sponsors and award recipients stay on this Zoom call for a very quick photography session. Thank you so much to everyone who has been staying with us to watch the live stream. And thank you everyone as well who has made this competition